Dear participants to this webinar, warmly welcome. My name is Pascal Pichonnat, and as president of the European Law Institute, it is my privilege and great pleasure to welcome you all to this webinar on the 30 years of the single market. You might say that the ELI is ahead of its time, given that it is only on 1st of January 2023 that it will be officially 30 years of the single market. Yes, the ELI is ahead of its time, and it is good so. In May 2022, during a meeting between ELI representatives and the head of unit at DG GROW, Amaryllis Verhoeven asked whether the ELI would be ready to assemble a team to advise the Commission on possible improvements to the single market on the occasion of its 30th anniversary. The idea was received favorably by the European Law Institute. We decided to set up the team with previous reporters of projects run by the ELI that tackle issues which are related to the single market. You have some of them, not all, in front of you today. There will be a close meeting between the ELI and members of the DG GROW in December 22. So we thought it could be interesting to share the ideas which the individuals we picked up have made. The format of a webinar seemed therefore most appropriate. You will, however, have the opportunity to access also short papers they have prepared on our website on the theme that they tackle today. The primary addressees of these written statements are the European institutions, in particular the Commission, but this exchange is meant to support further reflections and analysis. In a way, this webinar will seek to supplement the written submissions, help then the members of the DG GROW to take note also of first reactions to these ideas. These ideas are, of course, personal ideas. They have not been submitted to the various bodies of the ELI, and as such do not reflect any official position of the ELI. However, one of the aims of the ELI is also to promote a better understanding through exchanges between lawyers in Europe. Undoubtedly, the single market is a central aspect of the EU and the work of lawyers in Europe. This is why the written submission will be circulated after this webinar. We will have today a wonderful panel of outstanding speakers. Before we begin, let me remind you that you can ask questions using the Q&A function, not the chat function that has been disabled. And without further ado, I suggest that we start. We will start with Professor Christiane Wenderhorst. She is the actual ELI scientific director. She was the European co-reporter of the ELI Principles for a Data Economy. And as you know, she's been professor of civil law at the University of Vienna since 2008. She's a founding member of the ELI, the immediate past president as well. She was president from 2017 to 21. And she is a division president of the humanities at the Austrian Academy of Sciences, vice president of the Austrian Jurists Association, and a member of the Austrian National Bioethics Committee, and of course, many other positions. So I think we are all thrilled to hear what you have to say, Christiane, and you have the floor.
Well, thank you so much, Pascal, for the kind introduction, and also for inviting me to share some very personal views on the data economy in particular. And I stress that these are very personal views, so they are by no means associated with any institutional position I've held within the ELI. It's just some considerations I would like to share about this topic and the digital single market. And I think we all agree that data is absolutely key for the European economy in the 21st century. So it's absolutely essential that our European businesses have access to the right amount of data, the right quality of data. So making data available has been one of the mantras actually of data policies over the past years. So we've seen open data movements, we've seen the FAIR principle. So it's all been about making more data available for the European data economy to really be boosted. And that is one paradigm and one mantra. But of course, on the other hand, we've had another conflicting paradigm, and that is protection, and most notably data protection. So the General Data Protection Regulation has a data minimization principle. It has data privacy by design and by default as really fundamental considerations. And you can add to data protection also intellectual property protection. You can add protection of important public policies, national security, and you can replace basically data protection by other very important things and values that need our protection. And so these are two conflicting paradigms. The one is open by default and the other is protection by default. And so one of the main challenges I would see within the data policies over the recent years is this tension, how to manage this tension between those two conflicting paradigms. And we've seen very different strategies how to manage this tension. The first strategy, and that was a strategy we see very, very clearly in the free flow of data regulation, for example, is to kind of carve out, in particular, personal data. And to say, well, the European data economy is a data economy of non-personal data, basically. So this is really the first strategy we see. Later, it became clear that maybe it's a little bit difficult because most data sets are mixed. And then we kind of enrich this idea of restricting the data economy to non-personal data by the formula that any kind of activities are without prejudice to data protection. So it's this without prejudice to data protection that we see in many different pieces of EU legislation since. And it's really important to stress this, that it's without prejudice to protection. But of course, it's very, very difficult for those who have to apply the law, for the businesses out there, for all the other stakeholders, to figure out what exactly that means. So what does it mean that all this is without prejudice to data protection? And what about all the other aspects of protection? So this is why we've seen a different strategy, a second strategy emerge. And that is the strategy of having organizational, technological, and legal safeguards for data sharing. And this is a new spirit that underlies very much the idea of a data trusteeship. And I'm very happy to see that this is now so popular. I tried to really argue for or plead for data trusteeship already very long ago. And I now see that this is really something that's being addressed. I see it in the Data Governance Act. I see it in the European health data space, which I believe includes a number of really interesting, very promising ideas how to manage this tension between open by default and protection by default. So this is the second strategy which I see in particular the Data Governance Act and the European Health Data Space. And now with the Data Act and also with the Digital Market Act, we see a third strategy. And this third strategy is very much focusing on the individual party, very much focusing on empowering individual parties, very much focusing on data portability. And to a certain extent, the ELI itself and the work the ELI has done has been integrated in that, and we are very happy to see this. So it's in particular the notion of code-generated data that's been taken up by the European Commission. It's also been taken up by other players worldwide. We're very happy to see this. And the idea is that a party that has made a contribution to the generation of data has certain rights in those data, including possibly a portability right, so a right to request the controller to transfer the data to another party of their choice. Now, this is now the third strategy we see, and I don't have the time to go into the details. I think it's a great idea. It's a good strategy, but of course it has its own problems. You know, we've seen the problems with consent within the GDPR. So there's a lot also room for abuse. So I think we really need to look at the protection mechanisms of the second strategy also. And I would like to conclude with really this remark that I think it's really important the EU tackles the issues of the data economy and makes sure European businesses do have this access to data. But we also have to realize that the EU is really addressing this at a breathtaking pace. So we've seen so many legal instruments emerge over the past years, some of them sectoral, but many of them also horizontal. And it's really, really important we create consistency. We have consistency between those legal instruments, because only if we have consistency, only if we take a holistic view and a holistic approach to the data economy, will we be able to really manage this tension between open by default and protection by default. And so I would like to close basically with reminding maybe the European legal community of whether we may have to take some time to reflect, to really make sure we get it right, really make sure we get it consistent, and maybe even reflect whether with all these horizontal and sectoral instruments, we may need something like a data code, European data code in the future. Thank you very much, and I'm looking forward to the discussion.
Thank you very much, Christiane, also for sticking to the very short time. I know it's very tight, but everyone does its best. Thank you very much. I introduce immediately our next speaker. She is Aneta Wiewiórowska-Domalgaszka, and she holds a PhD from Utrecht University. She is finalizing her habilitation at Osnabrück, and she's back in Poland. She was involved in the work of the study group on a European civil code as well. And as an EU consumer private law expert, she has vast experience in national and EU legislative processes. And I have to say that she is one of the reporters of the ELI's model rule on online intermediary platforms project. She has many other wonderful qualities, but I think it's time to give her the floor. Aneta, the floor is yours.
Thank you very much. Well, I'll be speaking about platforms, obviously. And my task today is at the same time incredibly easy and incredibly difficult. And why is that? Because we are just waiting for the huge legislative package to be published. So basically, it's too early to say how it's going to work out in practice, but it's already too late to say what we could have done. And of course, adopting this package has been a great, huge achievement on the part of the EU, but it's really difficult to say what the possible problems are when it comes to the substance, since we have to wait for the text to be published to actually become acquainted with what the text says. But since my experience as a lawyer very much refers to enforcement, I'm coming from consumer law. So I'd like to give a few remarks about the possible challenges that can arise with regards to enforcing platform rules, and not because of the content, because we should wait and see what precisely is in there, but because of how those norms are constructed. And well, it's not really surprising that the platform regulation, when it comes to the structure, will reflect the structure of the regulation that we have in the EU, which is kind of challenging when it comes to enforcing, most of all at the national level. But also because platforms have such a profound impact on how the market functions, how the society functions. And actually, they tackle every single aspect one can think of when it comes to the way the society and market function. Hence, the legislation that deals with platforms also has this quality of having an impact everywhere within the legal system at the national level. And of course, it would be lovely to have this very complicated legal phenomena to be regulated in very comprehensive, systematic way, just like Christiane ended with a proposal or idea of a code, but of course, this is not the case. And although the DMA and DSA are supposed to provide this with this comprehensive legal scheme for platforms, of course, they do not exhaust the regulation. We have acts that are going to apply to platforms as well outside of those. Plus, because platforms deal with or feed on technological advancements of today, every subject that is going to be discussed today and its regulation are going to apply to platforms as well. But I would like to point out just 3 points. First, it is going to be a huge effort when it comes to coordinating enforcement at the European and national level. Well, it might be challenging. Why? Because at the European level, you don't have these distinctions when it comes to regulation that exist at the national law. So the rules at the European level, they when you try to translate them into national legislation, they deal with every single branch of law you can imagine. And EU does not really recognize this. EU law does not recognize these distinctions. So, for example, you have a lot of private law regulation at the European level, but the effectiveness that is expected of this regulation is of a public law character. And how to make sure that the private law is going to be enforced as effectively as public law. And I'm speaking from experience here. This is the typical situation with consumer law. Second, at the national level, because of these divisions, there will be a need to coordinate among branches enforcement within different branches of law. And this also is not as easy as it seems. It will require enormous effort, not only coordinate European with the national, but also within the national. And here, one should remember about the specific twist that platforms give us. So normally private law enforcement is difficult because it is up to people, to private parties, to decide to enforce their own rights. In case when the enforcement is supposed to go against platforms because of the extremely strong position of so many platforms, that will be difficult. If you think about the transparency and fairness regulation in B2B relations, I think that will be one of the greatest issues here. How to make sure that businesses that operate through platforms actually will be willing to enforce against platform and not be afraid of being excluded from the platform. And there are some suggestions or solutions to that in the regulation itself, but still, I think it might be difficult. But here we have another issue, which is the market position of the platform. And hence, of course, the European legislation, the European enforcement will be more effective because European Union is stronger together. But then we have situations when there is going to be investigation at the national level, there is going to be enforcement at the national level, or court cases. How to make sure that countries, national member states, will be able to enforce individually against platforms. And the last point I would like to mention is the kind of a paradox that appeared with the regulation, in particular with VLOPs, very large online platforms. So the danger that they bring about is that they regulate the market operation of the markets they create. So they are becoming private regulators. And introducing legislation at national or European level is supposed to take away this power from the platforms, to give democratic accountability to the rules that deal with the market functioning. But actually, right now we have a situation when the position of the private lawmakers of the platform are being enforced by the regulation itself. So we are facing a danger of a situation when we wanted to take away the power from the platform, but maybe we are actually giving more power to the platform. And my time is up. So just to sum up, we don't know how it's going to look, how the enforcement, how the situation with platforms is going to look in 3 years' time, let's say. Because that's when maybe first cases are going to appear with the 15 months of vacatio legis. But definitely, this is going to be a huge challenge. And even though I said so many, pointed out to so many potential problems, I think the sheer fact that the European Union has managed to adopt those rules stands for itself. So I think, well, there is a chance of them work out in practice. Thank you.
Thank you very much, Aneta, for these thoughts. And I see also the difficulty of enforcement of time, and not only enforcement of regulation. But thank you very much for these very important thoughts. I have now the pleasure to give the floor to Professor Juliette Sénéchal. She's professor of private law at the University of Lille in France. She conducts research and lectures in the area of European private law, e-commerce law, consumer law, and contract law. And she is also the director of a pole called Contract, Consumer, and E-commerce Law of the network Trans-Europe Experts. And she has been the co-reporter of the ELI project on blockchain technology and smart contract. Juliette, you have the floor.
Thank you very much. So I will share my screen in order to show you my PowerPoint concerning the topic I will present in front of you. So, which is a topic concerning platforms, blockchain, and non-fungible tokens. So I will try to explain you the articulation between several new realities of the digital world, and I will try to share with you some questions I have concerning the articulation between these three new realities. So centralized online platforms and decentralized blockchain are two technical, economic, and legal realities that are usually analyzed separately. But in fact, at the moment, the current approach may envisage the articulation between the centralized platform and the decentralized blockchain by means of non-fungible tokens, NFTs, in order to produce a renewed form of exclusivity on digital content or on digital services, which holder could use maybe either in the real world or in the parallel world of the platform, and maybe in the future metaverse. So the use of the non-fungible tokens raise many questions. And at the moment, there is no real answer concerning these questions in the current or future legal instrument concerning digital economy. So yes, it's okay. So as a reminder, what is exactly a blockchain? A blockchain is several types of technologies. You have a decentralized algorithmic consensus. You have a chain with a hash function using cryptography, and you have a distributed storage of a ledger between several nodes or computers. So the decentralized consensus is used concerning the validation of the transaction on the blockchain, and the storage is distributed. So you have both kind of concept, decentralization of the validation and distribution of the storage. And what is important concerning blockchain is that transactions on blockchain are isolated by design. This is something very interesting, but also very problematic, because blockchain is seen as a closed world, by reason of integrity. So data must not be altered by a centralized external source that does not respect for the decentralized nature of the blockchain. So it's important to have this isolation by design as a very important concept of the blockchain. The problem is this isolation by design. So the problem with this isolation by design is that it's not possible to do all what a blockchain can do due to this isolation. That's why there is a creation of another notion that breaks this isolation. It's the Oracle, which is a service that updates a blockchain using data from the off-chain environment, for example, for the need of an on-chain smart contract. So, and the limit of this Oracle, so this service that will put some information from the off-chain environment, the limit of this Oracle is that it introduces a form of centralization with a new trusted intermediary. So it's a kind of weakness for the blockchain, but it's also something that allows new possibilities. And it's exactly the case concerning the non-fungible tokens, because the prerequisite for the issuance of a non-fungible token, it's that it will be issued by via a centralized platform operator. So this is necessary for the circulation of this token. Or what is exactly this, a non-fungible token? It's a non-duplicable and individually identifiable token, which is said to be non-fungible. And this characteristic is due or is created by association to each of the token with a unique number of or a unique information that will distinguish it. So the issuance of this kind of token is a process that is not totally decentralized, because an issuer is needed, and this issuer is a trust third party, like an Oracle. And so the circulation of non-fungible token create the articulation between the decentralization and distribution of the blockchain and the centralization of a platform in order to issue this. You probably heard or such as a token linked to a work of art, a digital work of art created by people, for example, and the very high price for buying it. So this non-fungible tokens, the issuance of these non-fungible tokens, and the possibility of the circulation of these non-fungible tokens at the crossroad between blockchains and platforms and centralized platforms raised an abyss of questions. And if we only stay at from a contractual point of view, it raises lots of questions, such as the qualification of the contractor receiving the non-fungible token. Is or she is a consumer, a professional, a purchaser, a buyer, a client, a speculator, a donor, or a victim. All these questions, all these answers are possible. And at the same, what are the qualifications of the contractor providing the non-fungible token? Is he or is she an author, a copyright holder, an influencer, a vendor, a supplier, an online platform operator providing an intermediation service, a marketplace, a digital asset service provider, a crypto asset service provider? All the possibilities also are able, and what is important to say is that you have several regulation or directive at the moment. You have the directive concerning the contract for the supply of digital services, but you have also in the very next future a regulation on the market for crypto assets, and we don't know in which kind of area we are exactly. What is the qualification of the contract? What is the and what exactly does the contracting party who receive the non-fungible token will really receive? What is the value he will really receive? So it's will he receive only a line of code, an absolute intangible asset, a right in OM, a personal right, a line of code referring to an underlying tangible or intangible assets, etc., etc. So is it a category of evidence? Is it a title deed? Is it a means of appropriating the body or the fame of a physical person? It's quite difficult to know at the moment. And on the side precisely of the buyer,
Juliette, you need to get to
from the side of the buyer, the last question is the non-fungible token of interest in the real world, or is it only of interest in the metaverse? It's an important question because so metaverse will create a virtual, persistent, interactive, and immersive world, and probably it will need a register or ledger on which could be recorded via an NFT some kind of exclusivity on new work of art or new immaterial spaces in which a user of the metaverse will live. So this is the last question, and I thank you very much for your attention.
Thank you very much, Juliette, for these thoughts. And indeed, it opens an abyss of problems, issues to solve in the next 30 years, maybe before, hopefully. We have now the pleasure to come to Bernhard Koch, Professor Bernhard Koch. He's professor at the University of Innsbruck in Austria. He's an ELI council member and was the co-reporter of the ELI project on the reform of the Product Liability Directive. And he's currently the Dean of Studies at the University of Innsbruck. He's a member of the European Group on Tort Law and many other positions. In sake of time, I give you the floor immediately, Bernhard. Thank you.
Thank you very much for your kind introduction. Ladies and gentlemen, welcome. My task today is to talk about product liability in the digital age. And my role today is somewhat unique and different to the role of others on this panel, because the European Commission has just published a draft of a revised product liability directive last Wednesday. So I will try to look at this draft very briefly, particularly through the eyes of what the European Law Institute has produced so far on this topic. And I will, for the sake of time, limit myself to the ELI guiding principles for updating the product liability directive, which was published in January 2021. Now, obviously, the starting point is that products and markets have changed substantially since the original directive was drafted and introduced. I don't need to explain that further, I guess. But the key change, perhaps, is that even products of a type that were already available in the 1970s when the current directive was drafted now have features that were unimaginable at the time, often allowing the manufacturer to either directly alter them once the products are already in the hands of the final user, or at least give the latter the possibility to install such updates provided by the original manufacturer. And this obviously blurs or even eliminates the relevance of the moment when the product was first put into circulation for determining who should bear the risks of potentially harmful aspects of the product. This also makes it more difficult to rely on presumptions regarding in whose sphere was the origin of the harmful features of the product. So the magic moment of the PLD at present has therefore lost its relevance, even for products of a kind already available in 1985. And for that reason alone, it is imperative to adjust the PLD accordingly. And the second key change needed is an express clarification whether products falling under the directive need to be tangible or whether it also extends to purely digital products. This is not equally urgent as the former aspect. Denying its application would not affect the viability of the PLD, as one could well imagine a separate instrument tailor-made for software and other non-tangible items. However, this would clearly only be the second best solution, if only for the problems of drawing the line between those two then instruments. So it is preferable, of course, to expand the scope of the PLD. And both these concerns mentioned so far, at least to some extent, have already been taken care of by the proposed revision of last week. The definition of a product in Article 4, paragraph 1 of this draft now expressly not only includes electricity, but also digital manufacturing files and software. And even more importantly, the term component is defined as, and I quote, any item, whether tangible or intangible, or any related service that is integrated into or interconnected with a product by the manufacturer of that product or within that manufacturer's control, end of quote. So the concerns of the ELI guiding principle number 4 seems to have been adequately addressed here. In Article 6 of the draft, the exclusive focus on the moment when the product was initially put into circulation is replaced in cases where the manufacturer retains control over the product after that moment with, and again I quote, the moment in time when the product left the control of the manufacturer, which of course is a much more precise wording as in the current text. This shift, also proposed elsewhere in the draft, does not show in all places where one would have expected it. In particular, the long stop prescription period for personal injury in draft Article 14 at the moment still starts with the initial circulation of the product and does not pay attention to subsequent updates. If the scope of the PLD is expanded to include digital products as currently proposed, necessary follow-up questions arise, in particular with regard to artificial intelligence and its peculiar features. Self-learning and self-adjustments are core elements of this technology, of course, and if these built-in abilities themselves, without ongoing input by the original manufacturer, evolve in a way that renders the product ultimately harmful, this development seems to be no malfunction at first sight, as the AI was purposefully given the ability to alter itself in that way. Particularly in light of possible flaws of the initial design of the AI, and the question to what extent the algorithm should have had built-in barriers for such adverse changes, this primarily triggers the need for adjusting the notion of defectiveness, especially if consumer expectations play an ongoing role in that regard. Article 6, paragraph 1 of the draft indeed addresses that problem and specifically lists, I quote again, the effect on the product of any ability to continue to learn after deployment as one decisive factor determining the safety which the public at large is entitled to expect. The black box nature of the AI and the interconnectedness make it more difficult for victims to identify the true source of their harm. This justifies amendments to the PLD with respect to the claimant's burden of proof. Also in this regard, does the proposed directive already now suggest some improvements of the claimant's position, starting with a requirement to disclose internal information. More importantly, Article 9 of the draft shifts the burden of proof in two very significant scenarios. There is a presumption of defectiveness if only the claimant can prove that the damage was caused by an obvious malfunction of the product, but more specifically, the burden of proving the defectiveness is shifted where the claimant faces excessive difficulties due to technical or scientific complexity. And this is triggered as long as the claimant can also show that the product contributed to the damage, and again, I quote now, that it is likely that the product was defective or that its defectiveness is a likely cause of the damage, or both. And the latter in particular effectively seems to lower the standard of proof in those jurisdictions which otherwise insist on a higher degree of probability than just likely. Cybersecurity is also addressed, but for the sake of time, I will not go into details here. All in all, I think the new draft has taken a major leap into the right direction. Some of its language will still need to be put under closer scrutiny in light of the manifold scenarios that one might imagine, of course. But there have been remarkable changes, some deplorable omissions. On the other hand, the development risk defense was preserved. And even worse, I think, the directive at the moment still ignores the need to specify the objective state of scientific and technical knowledge in times of Google and DeepL. But to end with a positive note, ELI Guiding Principle 7 was taken care of by adding loss of corruption or corruption of data that is not used exclusively for professional purposes to the definition of compensable harm. Thank you.
Thank you very much, Bernard. And I think the Product Liability Directive is at the center of the single market, 1985. And now we are getting to a kind of second phase of this Product Liability Directive. And that promises to be challenging and interesting. Thank you very much for that. We get now to the last panelist today, Professor Teresa Rodriguez de las Heras Valel. She's a professor of commercial law at University Carlos III in Madrid, and actually Sir Roy Good Scholar at UNIDROIT for 21-22. And among other activities, also an arbitrator at the Madrid Court of Arbitration and the Spanish Court of Arbitration. She has been a member of the European Commission Expert Group on Liability, and today she will address also in her function as a co-reporter on a project on algorithmic contracting. Teresa, you have the floor.
Thank you very much, Pascal. I'm indeed delighted to have the opportunity to share with you in this panel, in this webinar, my views on what do we need to ensure that we unleash the potential of automated decision-making, and what do we need to consolidate a real digital single market for ADM, automated decision-making, and algorithmic contract. And we have to start by acknowledging that our society, as a complex, dynamic, over-informed society, largely benefit from automation. We need to automate a variety of tasks, a variety of activities, and even a variety of decision-making processes. Even more, we are incorporating extensively algorithm and automated decision-making throughout the contractual life cycle. So if we assume that we need algorithm for the purpose of automated a variety of tasks, from very single and very simple tasks such as searching or comparing or prioritizing, to even very sophisticated and relevant added value tasks and activities such as recommending, such as complaint handling, rating, ranking. The question is, if all these kind of activities are driven by algorithm and artificial intelligence system, do we have a coherent, consistent legal framework for automated decision-making in Europe? It's true, and we have to recognize that the risk, because there are more and more visible risk and even more and more preoccupying risk arising from the intensive automation. But the risk and definitely the potential and the benefit have not gone unnoticed to the European Union initiative. Indeed, we can find a number of principles that have been already crystallizing in a number as well of legal provision in existing initiative that are going to be adopted in the next month. Naturally, we can take a look at the GDPR and we immediately see the centerpiece of automated decision-making in Europe, that is Article 22 of the GDPR, but it's clearly not an all-embracing legal framework for automated decision-making. We see that how in the platform to business regulation in the DSA, in particular, there are references to automated means. There are references to transparency of ranking and recommender systems. So they are clearly referenced to the use of automated decision-making for different purposes. Definitely, we cannot forget the important Artificial Intelligence Act and how from a risk-based perspective is trying to design as well a legal framework from a regulatory point of view to the use of artificial intelligence for certain purposes, but is not indeed a consistent and all-embracing legal framework for automated decision-making. We can see as well, for example, how the Chapter 3 of the proposal of a directive for platform improvement condition in the platform work include algorithmic management and add some very fundamental principle for the use of algorithm in monitoring performance and applying certain sanctions. So we see how there are already building blocks in the European Union legal framework. But my point is that we do not have yet a predictable, reliable, consistent, all-embracing legal framework for automated decision-making and for the use of algorithm and artificial intelligence system in the context of transaction. So in transactional context and therefore for contractual purposes. That is the reason why the ELI innovation paper, the ELI guiding principle for automated decision-making in Europe, tried to contribute to this exercise, providing guidance for this building of a conducive and enabling legal framework for automated decision-making. And there are some questions to ask. For example, are we completely sure that in the existing legal framework is clear that the use of automated decision-making is valid and enforceable in all cases, even without an explicit legal recognition? Can we, for example, be sure that we have a principle that helps us to attribute the legal effect of the decision and action taken or adopted by autonomous decision-making? Do we have mechanisms to allocate the risk and liabilities? Certainly, as Bernard was referring to before, the fact that we have already this proposal, the two proposals related to liability in smart product and artificial intelligence system help a lot to solve this question, but probably we need to consider that carefully. Do we have mechanisms to ensure traceability of all the automated decision-making in all cases? Do we guarantee that all these decisions are reasoned and they are not arbitrary, and therefore the victim or the affected person has all the mechanisms to access to justice and be properly defended in case that some right has been infringed or has damage has been caused? Do we have the mechanism to make a transition from purely law compliant algorithm to essentially responsible algorithm? Plenty of these fundamental values that we are building as our society in Europe. What do we have to need? What do we have to do? What do we need at the moment? In my opinion, we need to follow 3 steps. The first one is a thorough and deep analysis of the existing rules in order to identify to which extent we have the blocks, we have the component to build up this aspired, hope for legal framework for automated decision-making. Second, as we are doing in the algorithmic contract, in order to conclude in less than a minute, as we are doing in the project on algorithmic contract, we are trying to ensure that the existing consumer protection rules, in particular, they are ready for automated decision-making, what we call ADM, automated decision-making readiness test. And only then we should produce, as Christiane referred, this idea of a code. It's exactly the same holistic vision. we have to be sure that we have a coherent guide of all the different principles and legal provisions that are relevant for the purpose of using and implementing automated decision-making in all different activities. Thank you very much, Pascal.
Thank you very much, Teresa, also for these insightful remarks and considerations. Now, the time is running, of course, and we know then when we have a lot of panelists and little time, it's always difficult to have enough space for questions. I do not have any question in the question Q&A box because that's the only way we can take questions today. We cannot have oral questions because we have only, let's say, 10 minutes or so to get some questions. But maybe I could just say that in a kind of summary of what you, no, I cannot summarize what you have said, but in a way to realize the challenges of the single market, I wanted to say for the next 30 years, looking backwards and forwards, one can see how difficult it will be in a sense, because as rightly said by Christiane Wenderos, you have this tension between open data and protection. And of course, at the same time, this open data and protection issue and tension is reflected in what Juliette Sénéchal mentioned about the NFTs and the need, of course, for a flow of data to ensure some of the decision-making processes that also has been underlined by Teresa, saying, okay, is the single market ready for automatic decision-making systems? And if so, what is needed? Should we have some specific regulations? And of course, Aneta Wiewiórowska came up and said, yeah, this is all fine, but we need enforcement. And the difficulty by enforcement is that you have difficulties both in the vertical approach between the EU and the member states, but also within the member states, given the complexity of the various areas of law that are tackled by these issues. And also on the top of that, I wanted to say, because of the fact that the primary addressees are also those who might have private regulation in place or put private regulation in place, making the tension even more important. And of course, the PLD as the crown, one of the first or the first private law directive of the EU, and now revised, taking into account all these developments. One can see that through these 5 presentations, we have quite a complex set of issues that will certainly occupy the EU for the next couple of years, for sure. And I see that there is now a question that disappeared. Okay, it was answered directly, I think, by Bernard Koch in writing, so that's fine. And therefore, I have a question by Jacques Foss to Teresa. I can read it. Would you agree that it is of the utmost importance that an ADM system should recognize its shortcomings, and in those cases would refer to an oracle in terms of blockchain and DLT? So Teresa, if you want to answer that, you.
Thank you very much, Pascal, and thank you for the question. I completely agree with the idea that ADM system, an AI system should indeed recognize this limitation, this inherent limitation. That is fundamental, for example, when we are talking about what is going to be the extent of explainability and the extent of transparency. Indeed, in our meeting, we have deeply discussed that point, to which extent the pure transparency is indeed sufficient and is going to be feasible and fit for purpose, when indeed the AD system in itself has limitation, has restriction, has shortcoming, as you mentioned. So definitely this idea of inevitable limitation of the ADM has to be incorporated in the kind of requirement and the kind of rules. And taking that into account, therefore, should we need this idea of a trusted third party, this idea of an oracle, in the sense that is the third party that verify, confirm, clarify, or even provide as a mechanism in order to exercise our right and solve conflict? I think is definitely a good method, a good tool to explore and incorporate in the this ADM global legal system that we are trying to build. Thank you very much.
Thank you, Teresa. And maybe just on the follow-up, there's also a question asking whether you think that, you know, the selection of the appropriate algorithm to ensure that it is ethically sound and works in a way without being under conflict of interest might be the main challenge in the future for companies.
Definitely, it's a great point. I think that we have to, now that we are still working on the, if I may, the legal aspect, the purely legality of algorithm, now we are really under pressure and we start thinking of the more ethical side of the use of algorithm. So this idea of responsible use of algorithm. And what means responsible? I agree with the point made in the question. It means that you have to select properly, that you have to design properly, that you have to monitor. Therefore, all these duty of cares are going throughout the whole process. And this is indeed very important. Let me just add a point in this regard. In the guiding principle of the ELI guiding principle, we have incorporated the principle of reasoned or reasonable decision. And this is very important because it's trying to avoid that companies, or in general providers and operators, may excuse themselves, alleging that the fact that it's opaque or is maybe unpredictable or is based on data that are completely outside of their control could produce unreasoned, arbitrary, or simply decision that cannot be explained properly for the purpose of the victim of the affected person to exercise the right. So I completely agree that we have to incorporate this kind of responsibility into the context of the legal framework. Thank you.
Thank you very much. Maybe I would address the next question to Christiane. There's a question saying, what about the courts and the lawyer skills? Because you spoke about open access, open flow of data and protection at the same time. And we see the complexity through Bernard Koch's presentation of, I mean, very, of course, short presentation of the new product liability directive. It challenges really the ability of judges and lawyers to understand everything. And of course, we might have aids to decision, but what is your position here, Christiane, maybe to come back to close the circle?
Thank you so much indeed for this great question. I think it's really a very important question that goes to the heart of what are we doing as lawyers with all this digital transformation. And there are various different answers to this, of course. And I think legal education in a certain way plays a key role here. So I think we need to rethink legal education. But of course, we need to bear in mind that this digitized world and AI is not the first very technical, very complex area which judges and lawyers have to deal with. So there is a lot of complexity also out there beyond AI, beyond digitization, and lawyers and judges have found ways how to deal with it with expert opinions and so on over the decades, and I should say over the centuries. But maybe that gives me the opportunity to make one point, and I think this is something that is also central to our discussion. We need to define what is the role of law and of lawyers in all this, because clearly a regulation and law can't fix it all. So it's a building block in a bigger picture of education, of technological development, of designing in a very sophisticated manner new intermediaries, new organizational structures. And I think we really need to approach all this from a holistic perspective and not just look at regulation, not just look at the legal sphere, because otherwise we will not be able to cope with these challenges.
Thank you very much, Christiane. I think we get to the end of the time that we were allotted to. Of course, each of your thoughts would generate a lot of discussion and further thoughts. And partly we will do that either with the Commission and then maybe in further webinars. I just want to mention that Mark Beamish from the DG Grow has mentioned that there will be webinar on the new product liability directive organized by the EU Commission on the 20th of October. He put in the Q&A the web page where you can register. So I wanted to mention that. Of course, the ELI is not here to do publicity for everyone, but for that purpose, of course, it's really appropriate. And I thank Mark Beamish for doing so. This is also a time to make some thanks to all of you, of course, all the attendees who took time on their lunch break to listen to these ideas and flow of comments about 30 years of internal single market, but also, of course, to our panelists. They took the time really to capture in a couple of minutes, which is almost impossible, some of the ideas. And as I said, you will get also some papers sent and available also on our website further in this week. So thank you to everyone for taking the time, for being here electronically, and let's see again very soon in person or online. Thank you. Bye-bye.